And then you heard Olivia Cakeling, who'd never been spoken to by anyone. You heard Olivia Cakeling take a stand and tell about a man coming from an alley that was connected to a building that was attached to the rooming house. She saw this man coming through that alley shortly after the killing, some minutes after the killing, and getting into a 1965 green Chevrolet that was parked on Hewling, and then speeding away north on Mulberry Street, right in front of the police, burning rubber as he went, with no interference whatsoever from them. All of these things, all of these events, I submit to you, are profoundly strong evidence of the existence of a conspiracy just at the local level. Not even mentioning the fact that the defendant has also indicated that planning sessions took place in his grill prior to the assassination. So I think it's important just to see that total picture of evidence you have, and there should be no doubt that all of these things are indicative overwhelmingly of conspiracy. Now, are we conspiracy buffs because we find all of this evidence insurmountable? I think not. But you have heard it. The masses of Americans have not, and the media has never put it to them, and I submit you probably never will. That's why your presence is so important. The crime scene. What about this crime scene? We submit that the crime scene, of course, was the back area of the rooming house. It was terribly overgrown with bushes. The bushes were thick, and they were difficult to penetrate, and that they provided an excellent sniper's lair. And that's where the crime took place. Any number of witnesses and evidence on the record indicates that a person or persons was seen in those bushes at the time of the shooting. These are different accounts that we put into the record, separate and apart. There is other evidence, again, separate, independent evidence, that a person was seen jumping from the wall, jumping over the wall and running up Mulberry Street. As a result of this, we have concluded some while ago, and have tried to provide enough impetus for you to conclude, that the shot came from these bushes and not from the bathroom window. The bathroom window and the rooming house bathroom has been officially the scene of this crime forever. The state had evidence long ago that was not the case, that the dent in a windowsill was not made by the rifle, even though they maintained that was the case. The bathroom was seen open. The state's main witness was drunk at the time. He was intoxicated. He couldn't identify anybody. Captain Tommy Stevens said he could hardly stand up, much less identify anyone. Yet it was the affidavit of Charles Whitman Stevens that brought James Earl Ray back to this country from England. That was the basis of the proof that brought him back. You know the confidence the state had in their own chief witness? They didn't even call him at the time of the guilty plea hearing. He didn't even testify at that point. Now the murder weapon itself. Judge Joe Brown heard testimony and evidence in this case for about 4 years. He paid particular attention to the weapon, and he's had a lifetime of experience and developed knowledge about weapons and about rifles in particular. We qualified the judge as an expert. He came before you. He sat there. And anyone who heard Judge Brown's testimony with respect to that weapon should have and weapons in general, should have no idea, no doubt whatsoever that he is in fact an expert. The media will point to his lack of technical training, courses having been taken with respect to learning about rifles. The other area for developing expertise happens to be in experience and self-knowledge and development, which is what Judge Brown has. Judge Brown sat in that chair, gave you ample technical, scientific reasons why that weapon in evidence is not the murder weapon. Very clearly. He said, first of all, the scope was never sighted in, and because it was never sighted in, if you use that scope, quote him, you couldn't hit the broad side of a barn. He said also that the death slug did not have the same metallurgical composition as existed in the lead of evidence, other evidence bullets that were found in that bundle. The state had always said that the death slug was one of a number of bullets that the defendant had, and that you should see them as a package, if you will. And Judge Brown said no. The death slug was different in metallurgical composition than the bullets that were there. Beyond this, there is evidence that you've heard that clearly couldn't have been the murder weapon, because the defendant told a taxi driver, James McCraw, to get rid of the murder weapon. And he did so. McCraw, being a close friend of Jowers, a confidant of Jowers, took the actual murder weapon and threw it off the Memphis, Arkansas bridge. So it's laid at the bottom of the Mississippi River for over 31 years. The real murder weapon is at the bottom of that river. Now, Bill Hamblin, no reason to lie, he said McGraw would only tell him this when he got drunk, and he told him this over 15 years. It was not something McGraw made up one day. It's over a period of 15 years. I remind you that he told this same story. Judge Arthur Haynes testified that he was, of course, James Earl Ray's first lawyer, along with his father. And he testified that in the course of their early on-the-scene investigation, they talked to Guy Knight, who owned the amusement shop, in front of which was found the bundle that contained, amongst other things, the rifle. And he said Knight told them very early on, before anyone else apparently had done any kind of tampering with him, told them very early on that that bundle was dropped some minutes before the actual shooting. Imagine that. That the bundle, the murder weapon, the rifle and evidence was dropped minutes before the actual shooting. How we come to Raoul, this shadowy figure, whom the defendant has mentioned, and whom James Earl Ray has talked about right from the beginning as someone who controlled him. You have a number of independent people, not even knowing each other, who have identified this man from a spread of photographs that they see. And they range from an English merchant seaman who we had to depose by telephone at some length, who ran into the same Raoul at the same bar James did up in the Neptune in Montreal. They range from him to the Graybones, Royce Wilburn, to the defendant himself, who identified Raoul from a spread of photographs before Ambassador Young and Mr. King, and of course James Earl Ray, who also identified him. That's not enough. If that's not enough, we have the British film producer, Jack Saltman, going to the door of Raoul's house, showing a photograph, and having his daughter admit that that's the photograph of the father, with words to the effect that anyone can get that picture of that photograph of my father. It's from Immigration and Naturalization. She identified her own father as the person in that photograph. Under subpoena and reluctantly, a Portuguese journalist took the stand. She had conducted an interview with a member of the family. The member of that family had told her that this was a horror, a nightmare for them and for the family. But the one comfort they had was that the government was helping them. That the government had sent people to their homes, approximately 3 times or so. That the government was monitoring their telephone calls, and the government was providing them with guidance. The government was trying to give them comfort and advice. Can you imagine if anything like that happened to any charges were laid against any of us in those circumstances? Do you think the government would come around and see us and help us monitor our phones? That act alone indicates the importance and the significance of this man, Raoul.